I was riding my bicycle when I rode over a pothole, which threw me off my bike and caused a serious head injury. Do I have a case, and whom do I sue?
That's a lot of issues in a case like that. I've tried to cover a few of them. The first being, everyone knows that roadways have potholes in them. And normal people riding bikes expect potholes to be in roadways. So as a practical matter, what needs to be determined first is how long that pothole has been there. If it has been there for an excessive period of time, and either the property owner or the government entity that owns the roadway or controls the roadway had knowledge that that pothole was there and was dangerous and didn't go out in time to fix it, then that defendant can be liable. Also need to determine whether the plaintiff saw the pothole or should have seen the pothole and rode his bike around it. In some circumstances, potholes are out in the open, they're obvious, and they can be seen by someone who's paying attention. So in those types of cases, a plaintiff would certainly bear some comparative fault for not seeing the pothole and riding around it. And other times, it's very difficult for a reasonable bicyclist to see a pothole in time to take evasive maneuvers to avoid it. But again, in those cases, what's critical is how long the pothole has been there. Does the property owner know the pothole has been there, or should the property owner have known the pothole was there? And what did the property owner do to try to address that pothole prior to the collision? Other factors that are important is whether or not other people have fallen in that pothole or crashed their bikes because of the pothole. And whether or not the defendant knew about that prior injury or crash and did anything about it. So those are some of the issues that arise in a case involving some sort of defect in a roadway like a pothole.
Is there any different statute of limitations depending upon whether it's owned on private property or public property?
Yes, there is. Under California law, if we're dealing with a private property owner, the plaintiff or injured party has 2 years from the date of the injury to file a lawsuit against the private property owner. If the property owner is a government entity, then under California law, the plaintiff or injured party has to give what's called a notice of claim to the government entity that owns and controls the roadway of their being injured. That notice of claim, again, has to be filed within 6 months from the date of the injury. After that is done, the government entity will either engage the plaintiff to resolve the case, which is very rare, or deny the claim. Once that claim has been denied by the government entity, the plaintiff then has 6 months from the date of the denial to file a lawsuit in the state of California.
And what happens in a case where I'm injured? Let's say I hit a pothole, and I believe my injury is going to get better over a period of time, and it's now a year later or 2 years later, and the pain has just gotten worse, and now I need to go in for reconstructive surgery. Have I forfeited my right to sue either the governmental entity or the private property owner?
If you don't abide by the deadlines, either the 2-year statute of limitations for private property owners or the 6-month notice of claim requirement for a government entity, believing that your injuries are going to get better and they didn't, then you have, in most circumstances, lost the right to recover from either of those entities. That's why it's important, again, to engage a lawyer early so this advice can be given to you and that the facts of the case can be discovered and evidence preserved. Photographic evidence in these types of cases of the dangerous condition, either a pothole or a storm grate, are critical. A good plaintiff's attorney is going to anticipate all the future injuries that might occur as a result of your injury and investigate those. A good personal injury will talk to doctors and find out whether or not there's a risk that down the road this person, the injured party, might need surgery for something, and include that in the lawsuit. Because once a plaintiff either blows the deadline, statute of limitations, or the 6-month notice of claim requirement, or settles their case, that's it. There's only one bite at the apple in these cases. You can't come back later and say, well, I didn't get enough money from you, and I didn't know I was going to have surgery. You only get one shot at this, and you got to recover for everything that might possibly happen in the future. And to do that, you can't recover for everything. You can't just speculate on what might happen in the future. What you need is a medical doctor that will say that this injury or this future medical care is reasonably probable, meaning it's most likely or more likely going to happen than not happen. The fact that it might possibly happen is not good enough. A medical doctor has to say that it's probably going to happen in order for a plaintiff to recover for future medical expenses.
I was 15 when I was involved in a bicycle accident, and I believe I suffered a head injury, but my parents didn't pursue a claim. And now I'm 21, and I do suffer head injuries, and my doctor says he's pretty sure he can trace it back to the bicycle accident. Am I out of luck because the statute of limitations is run?
Unfortunately, you are, or that person would be. And in California, there are special rules that apply to minors or people that are under the age of 18 when they're injured. And what the law does is it tolls that child's statute of limitations until 2 years after the age of majority, which is 18. So a plaintiff that's injured on a bicycle when they're 15 and suffers a head injury has until their 20th birthday to decide to file a lawsuit. The law gives that 18-year-old 2 years to make a decision as an adult as to whether or not to proceed.